Good morning and happy Friday. Welcome to today's meeting of the Assembly Committee on Government Affairs for the 2025 legislative session. Will the Secretary please call the roll?
Assembly members Carter.
Present.
DeLong.
Present.
De Silva.
Here.
Edgeworth.
Present.
Flanagan.
Here.
Gallant.
Here.
Goulding.
Here.
Gurr.
Here.
Hunt.
Here.
Jackson.
Here.
Karras.
Present.
Kasama.
Here.
Wynn.
Here.
Chair Considine.
And I am here. We have a quorum. Welcome to the audience here in Carson City, those joining us by video conference in Las Vegas, and those over the phone. As always, I'd like to start with a few housekeeping measures. First, please silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to our committee secretary. When testifying, please turn the microphone on and clearly state your name and any affiliation for the record. If you are providing handouts, please ensure that hard copies are available for members of the public. Electronic copies should have been provided to our committee manager by 9 a.m. yesterday for our committee members. We expect courtesy and respect in our interactions during the meeting, even if we disagree with someone else's position. I encourage committee members to ask questions and engage with the material presented. If you do have any follow-up questions, please flag them for me so we can ensure that we balance our time effectively during today's meeting. And as always, committee members will be using their laptops to view handouts and other documents. Please do not interpret that as a sign of disrespect or inattention. Today, we will hear two bills. We will begin with Senate Bill 279, which revises provisions relating to law enforcement, and then we'll hear SB 155, which revises provisions governing peace officers. I will now open the hearing on SB 279. To present this measure, we have Senator Pezzina, and she will introduce her co-presenters. It's nice to have you here in Government Affairs, and please begin whenever you are ready.
Good morning, Chair Considine, Vice Chair Wynn, and committee members on the Assembly Committee on Government Affairs. Thank you so much for having me this morning, and I apologize for my tardiness. We did not have a quorum without me there to start Commerce and Labor this morning. For the record, my name is Julie Pezzina, representing Senate District 12 in Clark County, and I'm before you today to present Senate Bill 279, which revises provisions relating to law enforcement. This bill aims to enhance transparency and fairness in the investigative process for peace officers. With me today to present Senate Bill 279, we have Rick McCann, who I know many of you are familiar with, as well as Andrew Regenbaum of Nevada Association of Public Safety Officers and the Nevada Law Enforcement Coalition. At the chair's pleasure, I'd like to provide some brief overview remarks before handing it over to my co-presenters. Currently, law enforcement agencies are authorized to conduct investigations into peace officers based on complaints or allegations of misconduct. These investigations often involve interrogations and hearings, which require written notice to be provided to the peace officer involved. The notice must also include a summary of the alleged misconduct and other relevant details. However, there's a need to further specify the details included in such notices and to clarify the rights of peace officers during these investigations. As such, SB 279 requires that written notices provided to peace officers must include specific details about the alleged misconduct, including all relevant facts and the rules or policies violated. Additionally, the bill mandates that peace officers who are compelled to appear as witnesses must receive at least 48 hours written notice, as the officers are given already who are subject to the investigation. And at this point, I'd like to hand it over to my co-presenters, and I thank you so much for having me again.
Good morning, Madam Chair, members of the committee, and staff. Yes, sadly, many of you do know me. For the record, my name is Rick McCann, and I'm here today representing the Nevada Association of Public Safety Officers and the Nevada Law Enforcement Coalition. Nevada Revised Statute, Chapter 289, is otherwise known as the Nevada Peace Officers Bill of Rights. Quite simply, law enforcement officers are afforded basic due process rights, such as the right to be notified in a timely manner when they are to be interviewed by Internal Affairs, and the right to be notified with some specificity as to what misconduct the officer is alleged to have committed. That's just common sense, and it's just fairness to the officers. I think we can all agree on that. But when some agencies around the state play a little fast and loose with these rights, we need to tighten things up a bit. And with that, I will turn it over to Mr. Andrew Regenbaum to review the bill with you and let you know some of the specific reasons for the bill.
Thank you. Good morning, Madam Chair, committee members, staff. Thank you for having me here this morning. As you heard, my name is Andrew Regenbaum, and I am the Executive Director of the Nevada Association of Public Safety Officers. We represent approximately 25 different law enforcement associations around the great state of Nevada and over 1,300 law enforcement officers. I would like to say it's both fitting and an honor to be here during Police Week to discuss this bill. As you know, NRS 289 is the hallmark law that provides due process rights to law enforcement officers around our state. It's an excellent law, but in recent years, we have seen an increasing number of agencies finding ways to circumvent the language of the law in order to manipulate the outcome of investigations. The purpose of the bill before you, Senate Bill 279, is to codify the due process protections originally intended for 289 into specific words that will be within the statute. Now, what do I mean by that? First, originally the drafters of 289 intended for subject officers and witness officers to be given 48 hours notice of any investigative interview. That's a pretty simple thing. Unfortunately, while the language is very specific as to subject officers, some agencies have tried to suggest that a witness officer is not entitled to that same protection of 48 hours prior notice. This suggestion serves no purpose other than to potentially deprive the witness officer of their right to representation. Our language simply clarifies that the 48-hour notice applies to both a subject officer and a witness officer. The more significant addition to the proposed bill has to do with NRS 289.060 subsection 2, which is the notice provision that is required to be provided to an officer prior to any investigation. 289.060 subsection 2B requires that any agency provide the officer with, and I quote, a summary of the alleged misconduct. This seems simple enough and should be followed without question by any law enforcement agency. The intent of that statement is to avoid fishing expeditions or witch hunts against a law enforcement officer. In fact, it's simple due process that would be provided to any ordinary citizen. While some of the agencies in our state follow the clear intent of that language and give an actual summary of the allegations, we have found that more and more there are other agencies that are not providing a true or actual summary of allegations, thus leaving our officers open to questions without limitation and for which he or she were not able to prepare for what they were going to be questioned about. For example, we have seen in one city that the internal affairs investigators provided an officer with an interview notice about an alleged nepotism policy violation. In that same interview, questions came up about the misuse of his computers and harassment of an unrelated coworker. Both were entirely different situations. None of that was contained within the notice, despite the fact that Internal Affairs knew full well the nature of the allegations it intended to question the officer about. As another example, an officer was noticed for an interview about an alleged rude and discourteous traffic stop that, I will give you just as an example, may have occurred on January 1st of this year. The notice indicated that the officer would be questioned about a rude and discourteous traffic stop on January 1st to the present. That officer was then questioned about 5 additional traffic stops that occurred throughout the months of February, March, and April of that year, and the officer subsequently was harshly disciplined with regards to the unnoticed March traffic stop that he didn't know he was going to be questioned about. The officer was disciplined, according to the agency, because he was unable to answer questions about the stop when he had no recollection of the event, because he had not been able to review the events and the documentation of that event. We believe that was unfair. Frankly, either of these examples is completely unfair. They were an ambush and resulted in discipline that is now challenged through costly arbitration that is done pursuant to collective bargaining agreements. Those arbitrations between the associations and the city don't need to happen if we did this right. This would not happen to an ordinary citizen and should not be allowed to happen to law enforcement officers. In order to fix these issues, with the help of Senator Pizzino, we have proposed common sense legislation, and language that will simplify and clarify 289-060 so that it's very clear for the agencies to know what they should and should not provide as notice. This will actually work to help the cities and agencies because it takes away the procedural objections of the associations relative to what goes on in the questioning and the end result of those investigations. The language in the second amended bill that's before you requires the agency to include a summary along with the date, time, and location of the alleged misconduct, as well as a specific description of the misconduct or performance that's alleged to be a problem. This is not a difficult requirement. It creates no burden for the police agencies or cities that are involved. In fact, if new or additional information is discovered during an interview, NRS 289 already has provisions to stop the interview, give the officer a new notice, and restart a new interview with new allegations. Therefore, there is no prejudice to the law enforcement agency, despite anything they may say to the contrary. Significantly, I will tell you that there are a few agencies around the state that already follow these protections that we propose in Senate Bill 279. Metro, for example, gives a date, time, and place in their notice, and it's a part of their collective bargaining agreement. Lyon County, for example, lists potential policy violations of their officers in their notice, so that way there is a specific date, time, and location given out. Unfortunately, these agencies are in the minority. Many other agencies do not follow the law and need to be guided more specifically. This language which we propose, by placing it into 289, will do this and will protect the rights of our officers. Ladies and gentlemen of the committee, it is for this reason I ask you to please support Senate Bill 279 so that we all can do our part to protect the men and women who tirelessly protect each of us every day, 24 hours. Thank you.
Thank you for that presentation. We do have some questions. We will start with Assemblymember Goulding.
Thank you. Okay. Thank you. Thank you for the presentation. I have a question about the word specificity. There's sort of two parts here. So specificity seems a word like clarity or granularity. There's a range. It's not very specific, actually. So I'm wondering, when you say that the summary of misconduct has to include specificity, does specificity include only the date, time, and location? I'm wondering if you need to be clearer about what is included in specificity.
Thank you for that question, ma'am. This is Andrew Regenbaum, and in response to that, it would include not just the date, time, and location, but currently the language states that there should be a summary of the alleged misconduct. So that specificity language is supposed to amplify the summary part to include an actual description of what is alleged to be the misconduct at issue.
And this is Julie Pizzina, just to follow up. Even taking out the word specificity in Section 1 2B, it sets forth the alleged acts or omissions constituting the misconduct and the date, time, and location of the alleged misconduct. So even taking out the word specificity, it does definitely also include the alleged acts and or omissions. And thank you for the question.
Thank you. My concern is that if you say, please provide the details in the summary, but detail can be a broad or a really narrow, and this language doesn't necessarily clarify for me what those details should include. So that is, so thank you for the response. I'm not sure I'm still, that I'm there yet in understanding what that granularity should be. Follow up? Yes. Then the second question is, the summary must describe each allegation. So if you, if something else is discovered, I think that you're, just for a point of clarity, if something else is discovered in the questioning, there's a pause on that and you have to address that at a different time. Is that correct?
This is Andrew Regenbaum. That is correct, ma'am.
Thank you.
And if I may, Madam Chair, just to further address your first question, I think one of the issues that we've had relative to specificity with the current language only being a summary is that it allows certain agencies to say, I don't have to give you a date, a time, a location. And that was one of the specificities that we looked to address with the language in the senator's bill. There wasn't much of a way to describe that further than the word specificity without getting into real nuanced details of what you would expect. And then that would leave open that now you only have to do date, time, place, as opposed to the summary with specificity. If that helps a little. Thank you, ma'am.
Thank you. And it just might be a clarifying question, but in your presentation, you mentioned that under NRS 289, if there is something that goes off of what the intention of the meeting was, that it already allows for you to stop and reschedule. And I might have missed something. If you could just explain that piece again, because I know that's what this bill wants to do, but if it already does, I think I've missed something. So just for clarification, please.
Thank you for the question, Madam Chair. This is Andrew Regenbaum again. So currently, if a new issue arises that was not in the original notice, whether that comes about by learning something new from that questioning or there's clarification on something that was being questioned, the NRS requires that the law enforcement agency stop that interview, notify the peace officer that there's a different issue that we're going to have to question you on, and a new notice be provided. The time frame for a 48-hour notice can be waived, and the questioning can continue if the officer and their representative agrees, or a whole new notice is served and a second interview commences. That's what we were talking about with that.
And is that what is currently happening, or is that what you want to do for a larger group of people in this bill?
That is what we want to happen in this bill. The law requires that currently, but that does not always happen. Instead, you get a questioning that is broad, that goes into many different areas under the guise that this wide open summary allows us to go into anything as opposed to keeping it more specific.
Thank you. Our next question is from Vice Chair Nguyen.
Thank you, Madam Chair. Thank you, Senator, for being here, and as well as the representative. I just wanted to understand and maybe understand the process, right? The 48 hours seems to be highlighted a couple times, and I want to be sure that we give ample times for preparation of these kind of situations. So with shortages of staffing schedules, and I know we're feeling that pain across the state, not just, with law enforcement, is that a reasonable time for the officer to be able to get there and, rearrange their work schedule if they need to appear somewhere? Is that practice common in terms of your world, that is 48 hours, or we need to do more than 48 hours?
Thank you for that question. This is Andrew Regenbaum again. And in general, the 48 hours currently, the 289 has a provision that the 48 hours is your minimum amount of time, and there is supposed to be a reasonable accommodation both for the officer's schedule as well as the schedule of a representative. In general, we do not have problems with that. not providing 48 hours for witness officers has been a problem in several jurisdictions, and that then creates the problem that both the witnesses' representatives are not able to appear, and because they're a witness officer, the agency holds over that officer the threat of insubordination, which is a terminable offense if they don't appear regardless. So that is a problem. 48 hours in general is not, I mean, it is difficult. I can tell you that I often have to reschedule to appear with my officers because sometimes I have to travel. Sometimes it's just not possible based upon scheduling, but many agencies work with us on that.
Okay, quick follow-up, Chair. So just for, again, clarity, should another hearing occur within that first hearing, right? Do the 48 hours then again apply one more time?
Yes, sir. This is
Okay.
Andrew Reagan.
Perfect. I just want to make sure that we give agencies the ability to react on both sides.
Yes, and sometimes, as I answered previously, we are able to waive that 48 hours if everyone is aware of, in general, what the new questioning is going to be about. Sometimes you might take a pause or a break to have a discussion, with the officer, and then continue the questioning with that new notice right then and there.
Great. Thanks so much. Thank you, Chair.
Thank you, and seeing no other questions from our committee, I want to thank you for your presentation, and we will now move on to testimony. And testimony can be provided here in person in Carson City, via video conference in Las Vegas, or over the phone. And instructions for providing that testimony can be found on the agenda. We will begin with testimony in support here in Carson City. Please come up to the table and begin when you are ready to testify in support of SB 279.
Good morning, Chair and members of the committee. My name is Joshua Martinez. I represent the Las Vegas Metropolitan Police Department. We're here in support of SB 279 as it's currently written. We worked with the bill sponsor and the presenters of the bill to come to a resolution, to come up with the current language that they were able to review with you. And, the 48 hours clarification is to give the same that you give to a subject officer, 48 hours notice to the subject officer, which currently is in law. That, with this passage of this bill, would extend that 48 hours notice to the witness officers as well. So a witness officer would receive, if this bill is to go through, would receive the same 48-hour notice as a subject officer. And then also the clarity in regards to the date, time, and location to add that specificity, that way the officers have some idea of what they're going to be questioned about when they come for an internal investigation. We support this bill. I appreciate the opportunity to speak. Thank you.
Good morning, Madam Chair and members of the committee. Jason Lesher, Lesher, with the Washoe County Sheriff Deputies Association. Also here representing the Public Safety Alliance of Nevada, which represents a great majority of the police officers in the great state of Nevada. We are here fully supporting this bill for all the reasons stated. And just to Senator Wynn's 48 hours too, I just want to, that's the minimum, I'm sorry, apologies. The minimum amount of time is at 48 hours. We've never had a problem if we need more time to bring our attorney or prepare our witness, or if somebody's on vacation. The agencies are generally, as far as I know, very, very willing to work with that. So thank you very much.
Good morning, Madam Chair, committee members. My name is Jim Dunlap. I'm the president of Nevada Association of Public Safety Officers. I'm also a member of the Henderson Police Supervisors Association, and I've been a police officer for over 30 years. In my 30 years of being in law enforcement, representing folks that have gone through this process, seeing things have changed throughout the years. All that we're asking of the passage of this legislation is that we give the officers and their witnesses the same rights that we would give to any other citizen or to give to any other person that's been committed of a crime. The other part of that is the larger jurisdictions are already doing and putting this into practice. So NAPSO represents, as our executive director indicated, over 25 jurisdictions and agencies around the country, or excuse me, around the state. Some of them are relatively small. And all we're asking is, why shouldn't those smaller jurisdictions or those deputies or those officers in those other jurisdictions, why shouldn't they be afforded the same rights that the larger jurisdictions are already practicing? We believe that every officer in the state deserves the same due process and the same rights as everybody else in the state. Thank you.
Good morning, Madam Chair and members of the committee. My name is Chris Cannon. I am General Counsel for the North Las Vegas Police Supervisor Association down south. I appear today to speak in support of the bill as General Counsel and as a prior law enforcement officer for 27 years. I think this bill is necessary and needed for all the officers within the state. I think it affords an additional protection. I think there has been knowingly and maybe not so knowingly abuses of 289 that have resulted in litigation. And I think this gives clarity to the law to not only the agencies, but also the associations to understand the protections that have to be given to all police officers within the state. Thank you.
Seeing no one else in Carson City approach the table for testimony in support of SB 279. I don't see anyone in Las Vegas, but if there's anyone hiding out of camera view who wishes to provide support testimony on SB 279, please step forward. Not seeing any movement down there. We will go to AVH. AVH, is there anyone on the lines wishing to testify in support of SB 279?
To testify in support of Senate Bill 279, please press star 9 to take your place in the queue. Caller, go ahead.
Good morning, Chair Considine, members of the committee. This is Lisa Corrado, Lisacorrado. I'm an assistant city manager for the city of Henderson and wanted to share support for SB 279 in this current version presented by NAPSO and agree with the comments shared. We appreciate the changes and clarifications they're making and encourage passing SB 279. Thank you.
Caller, you are unmuted. Please go ahead. Caller with the last 3 digits, 167. You are unmuted on our end. Please make sure that you are unmuted on your end.
Good morning. My name is Sean Tebow, Thibeault, and I'm the president of the Henderson Police Officers Association, where I represent over 400 officers of the Henderson Police Department. I came to speak in favor of this bill today. During my tenure, I've witnessed the abuse of the IA process, where officers have not been given sufficient notice of an IA investigation and being too vague in the description of the alleged violation. I won't bore you with the details of NRS 289-060, as you've already heard the sections that have been quoted about 289. But if the proposed changes to NRS 289-060 are enacted, we will ensure that the NRS is followed and there would be no violation of Section 3C, which states, and I quote, that law enforcement shall limit the scope of the questions during the interrogation or hearing to the alleged misconduct of the peace officer who is subject of the investigation. This would eliminate efficient expeditions and witch hunts that have been testified to regarding this bill in the past by Director Regenbaum. Unfortunately, this has not been the case as current. I am also keenly aware that witness officers have not been given 48 hours notice as well. I've personally had to barge in and stop an IA investigation due to the department not providing proper 48-hour notice and thus violating the officer's rights in accordance to NRS 289. Your consideration of the passage of this bill is greatly appreciated and will serve to protect Nevada peace officers' rights in the future. Thank you.
Chair, we have no additional callers in support at this time.
Thank you so much. We will then move on to testimony in opposition to Senate Bill 279. Is there anyone here in Carson City wishing to testify in opposition? Seeing no one, and seeing the whole room in Las Vegas and not seeing anyone in there, we will move to, and thank you very much for that, we will move to AVH. AVH, is there anyone on the line wishing to testify in opposition to SB 279?
If you would like to testify in opposition of SB 279, please press star 9 to take your place in the queue. If you recently joined the call and would like to testify in opposition of SB 279, please press star 9 to take your place in the queue. Chair, we have no callers for opposition at this time.
Thank you. We will then move on to testimony in neutral. Is there anyone here in Carson City wishing to testify in neutral on SB 279? Seeing none, still seeing no one in Las Vegas. AVH, we're back to you for testimony in neutral on SB 279.
Thank you. If you would like to testify in neutral for SB 279, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in neutral.
Okay, thank you. Would the presenters do not want to make any final remarks? Thank you so much for the presentation. I will now close the hearing on Senate Bill 279, and we will take a short recess before we open up the next bill hearing. Thank you. Okay, we are back from our recess, and I will now open the hearing on Senate Bill 155, which revises provisions governing peace officers. To present this measure, we have Senator Flores, and just please go ahead whenever you're ready.
Oops. I just broke your mic, Madam Chair. My apologies. All right, I think we're going to make this work. There we go. Good morning, Madam Chair, Vice Chair, and esteemed colleagues of the very hardworking Assembly Committee on Government Affairs. I am State Senator Edgar Flores, proudly representing Senate District 2. I am joined alongside of myself by our amazing colleague, Assemblymember De Silva, proudly representing Assembly District 28. And I do think it is incredibly important to have him with me for this particular bill, because in drafting Assembly Bill 155, I was thinking about him and similar individuals living in my district who have done everything for this country and yet don't always have an opportunity to participate in certain things. So with that, by way of reference, I'd just like to very briefly go through what Assembly Bill 155, the genesis of is, how I believe this bill addresses that concern, and then I'd like to hand over the presentation to Assemblymember De Silva so that he can walk you through his own personal testimony and explain how this directly fits into his personal story and many other individuals like him. By way of reference, I am an attorney. I focus namely on immigration law. And in my private practice, every single day I have the honor and privilege of helping individuals become U.S. citizens, lawful permanent residents, or gain other type of lawful status in this country. And through that work, one of the things that I am often and most exposed to, it is this deep desire of service by individuals who are going through that process. A genuine seeking of an opportunity to be able to prove yourself worthy of what this amazing nation stands for. As we all know, we are in the single greatest country in the world, but we still have a lot of things we can fix. And the reason we're so amazing is because we've had the privilege of having individuals from all over the world come here after having served and seen what is wrong with other places and said, we can make it better here. It is the birth of our nation. It is the reason that all of us are here today. It is why we have the most diverse legislature. It is why we are the first women majority in the country. We are a testament of when we allow and give other individuals an opportunity who have traditionally been kept out of a space, how powerful we can make a place and how much better we can do it when we do it collectively together and recognize our differences as a source of empowerment rather than as a source of separation. So through that notion and through that lens, I've proudly had my brother who served in the military, and I've had other members of my family who served in the military very proudly. But we've had folk who were not U.S. citizens. They served in the military, and they did it honorably, and they were honorably discharged, and they served this nation knowing that they could have died on the line of duty. And by the way, a lot of non-U.S. citizens with our patch of our flag have died over the years serving this country. And they died, they were killed on the line of duty. And when we buried them as heroes for this country. Now, I say that because through Assembly Bill 155, one of the things that we realized that unlike what we're doing in 7 other states already, including Washington, D.C., where we allow non-U.S. citizens to serve as members of law enforcement. And what we wanted to do is clarify a couple of things. In speaking with members of law enforcement in different ages in the state, I learned that the current NRS wasn't always being followed. And what I mean by that is presently in the NRS today, right now, the law, even if this bill does not move, there is already a clause that allows for non-U.S. citizens to serve as members of law enforcement if they were honorably discharged from the military. That's already in the law now. But in speaking with different agencies, we realized that not everybody was following that and or had a clarity in that was the law now. So one of the things that we seek to do in Assembly Bill 155 is just make that clarification. So you'll see it in there in the language specifically, making it clear that if you've served honorably in our military and you've been discharged, you can, in fact, be a member of law enforcement. That's number one. The second thing, and it is very narrowly tailored that we are hoping to accomplish, is there are states that are already doing this, and there is a national trend because this has been in a recent history of our United States, going back about 8 years, where we've seen states starting to adopt similar like policies, where there are members of law enforcement in other states, and specifically, I know I mentioned 7, I know that as we're speaking, we're often researching California, Connecticut, Colorado, Illinois, New Mexico, Virginia, Washington State, and Washington, D.C. all have implemented much broader legislation than what we're seeking to do here, much broader than what we're doing here. All we are saying is that in the state of Nevada, we'll take a baby step so that we can all slowly start moving in a direction to see if we're okay with it, to get feedback in the next few years from members of law enforcement, from different agencies, to see if we think this is a good idea. And all we're doing in the second part of the bill is saying if you have served as a member of law enforcement in another agency in one of the states that already allows it, that we will allow lateral movement for you to come to the state of Nevada and apply. Now, this bill in no way mandates that we have to do anything. Nobody is obligated to have to accept an application simply because they came from a different agency from a different state or because they were honorably discharged. All this bill allows is for them to apply. That is all we're doing. They will still go through the regular vetting process. They will be held to the same standards as everybody else. And if it doesn't work, if they don't like them, if there's a flag, if there's still a concern on their background, they can still deny them. This is just allowing them the opportunity to apply. Now, before I hand it over to my my amazing co-presenter, I wanted to just give everybody some perspective on the amount of research and vetting that goes into an individual who wants to be in this country lawfully. So an individual that wants to become a lawful permanent resident. Presently, every single individual, before they can work in this country and be here lawfully, this is before they even become citizens. They will go through an FBI name check, which they call the NNCP, FBI criminal history check through that's fingerprint-based, the DHS Ident OBIM, which stands for Office of Biometric Identifying Management background check. They'll do something called TEX, which was formerly the Treasury Enforcement Communication System. They will put you through the National Crime Information Center, SEVIS, which is a Student Exchange Visitor Information System. They will review your case, your database also in any terrorist screening database, and to see if you're on a no-fly list like Interpol and other global security checks. They will do all of that. Then you are authorized to work here and be in this country. Now, for individuals that have been honorably discharged, they also went through a background check to go into the military. So now they've gone through all these background checks. Now they've gone through the military background check. They've been honorably discharged. And now they're coming to Nevada and they're going to apply and go through another extensive, incredibly onerous background check that law enforcement does in the state. And after all of that, they can still deny them. They can still say, no, we still have a concern on this. We're not sure about this issue. They can still say no. In addition to that, I wanted to make it abundantly clear. We've all heard of the one-off, the uncomfortable bad apple scenario where an individual had a criminal conviction or was fired from a different state agency, and then they come and then join, not specifically in Nevada, but we've heard of lateral movement between agencies where they got in trouble in one state and then they went to another state and then applied and got right in. The reason I wanted to make that point is if you are in this country as a lawful permanent resident or under some status, and you make a mistake, unlike a U.S. citizen, you can get deported. So they have to adhere to an even higher standard because a mistake from a non-U.S. citizen, not only does it mean termination from their employment as a member of law enforcement, but it also, for that specific individual, means they could be deported. So not only will they adhere to all these different databases, by the time they apply to law enforcement here in Nevada, that employer, and I am an employer, and I think that as an employer, I would be much more confident knowing that this individual, this applicant, has gone through all these background checks, has gone through all these requirements before they come even to my door. Because I know that individual must had to adhere to a much higher standard than any other applicant that's a U.S. citizen. And then on top of that, I know they have to be on their best conduct always, because if they ever make a mistake, not only can they lose their job, but they can get deported. So for those reasons, we think that this is an important opportunity for us to acknowledge the contributions of our immigrant community, acknowledge the rich history of our country and what it represents and what it stands for. Because every one of us, if we go far back enough, we can trace our lineage to a situation where we had to flee another country because it was inadequate for our families and for our values, and we arrived in the greatest nation on earth. Through that sense, then I invite you to explore this with me. And in a time presently, where in the state of Nevada, in our healthcare industry, we allow for amazing immigrants to serve teachers. In the most important sectors of this state and in this country, we allow individuals wishing to prove themselves to serve. I think it is now time that we become current with what the reality of our nation is today, and we allow these individuals to at least apply for our agencies. With that, I'd like to hand it over to Assemblymember De Silva.
Thank you, Senator Flores. Thank you, Madam Chair and Assembly Government Affairs Committee for having us this morning. My name is Assemblymember Ruben De Silva, for the record. And just before I even get into my comments, I should say that Senator Flores asked me just this morning to speak on this bill. And I feel very strongly about this notion here of the real nexus between immigrant experiences and public service in this country. And many of you received this email just last evening. I'll just read the first paragraph from it. It says, please vote no on SB 155. People who are not United States citizens should not be serving as peace officers in Nevada. It is difficult for law enforcement to vet the criminal background of foreign nationals. Also, citizenship should mean something. Peace officer positions belong to the citizenry, not foreigners. Foreigners who have no vested interest in our national interests. So I think the rhetoric has really been focusing on this idea that if you're an immigrant, even if you are a permanent resident in this country, you don't care about this country, you can't be vetted, your background can't be looked into, and that you have a different sort of interest, one that is not in line with the national public interest of what an American citizen espouses. And that's when Senator Flores reached out to me and said, talk about your own personal story and your own commitment to this nation. So many individuals know here in this building that I was a formerly undocumented person in this nation. I had no papers until I was 13, but that didn't stop me from participating in my community, from working as as somebody who cared about this nation and wanted to see this country succeed, even though people were telling me that I should be deported, when I was a young person in this nation. Afterwards, even without having a citizenship, I joined the U.S. Marines when my nation needed me. This was during the 2003. The war in Afghanistan was raging. The war in Iraq had just begun, the March of my senior year. And I felt that it was the right thing for me to do, that though I was not a citizen, I couldn't even vote. I had no sort of ability to participate in actual electoral politics, but I felt that it was the right thing for me to do at that time as an 18-year-old, to join this country and to serve this nation in its armed services. And I was deployed to Iraq. In the thick of it, I went to Fallujah, that Sunni Triangle. And I was not a citizen when I was injured in the war. When I took that sniper bullet and shed blood for this nation, I was not a citizen. I had no ability to participate in elections or vote, none of that. But it didn't stop me from exuding my duty to the services of this country. And while I was out there, I was very privy to some to security conversations, intelligence briefings about movement of enemy troops, about the sort of weapons they were using against us. I was in those meetings and sometimes even led some of those briefings as a non-citizen. So that also now really brings us back to this conversation about the role of immigrants and especially permanent residents vis-a-vis how we want to serve and exude ourselves in this nation. You know, when you look at like there's a lot of debate in the scholarly community about how do you socialize new Americans, folks who are coming to this country, immigrants who are now looking to be here permanently. And there's four real sort of pillars that they identify. And this is the scholarly sort of like a discussion. They look at the front lines, really. They look at education, you know, healthcare, entrepreneurship, jobs, economy, and public safety. So aside from public safety, you look at the other three. Teaching. You know, I'm a school teacher. You know, that's the front line, you know, of our education system. You look at K through 12 in this state. We changed the actual laws to allow non-citizens to serve as teachers. I believe it was the 13th session or the 15th session. And we've seen that they've been some of the most hardest working of our teachers. We're having a great conversation and debate this session about the J-1 visa Filipino teachers this session, who tend to be some of the best and most dutiful teachers in our school system. You look at jobs in the economy, there's no question that immigrants, especially those who are here on visas and permanent residency, are some of our most thriving entrepreneurial elements of this nation. There's no question about that, from Fortune 500 companies all the way down to our small moms and pops businesses in every nook and cranny of the United States of America, and especially in the state, whether you're talking about Las Vegas or even the rurals. The immigrants are there and vibrantly pushing forward our economy. And healthcare is another industry too. Myself and Assembly Member Vice Chair Wynn have had this conversation many times about the role that immigrants play in our healthcare system. You look at the nursing population in the Western United States, 33% of them come from one country, the Philippines. You look at doctors in Nevada, come from, you know, again, the Indian American community, the community that I'm from, makes up less than 1% of the Nevada population, but makes 28% of every single doctors in this state. So we are very present there in this element of socialization, healthcare. The last one has been public safety. There has not been an opportunity, really, we believe, for immigrants to serve, you know, in that role. Across the board, again, scholars say that these are how you socialize Americans: work in our healthcare system, make America a healthier country, participate in our economy, in our entrepreneurial elements, serve in education. You know, and the other part, we talked about K through 12, but then when you look at higher ed and the amount of immigrants who participate as professors, as researchers in this country, I think that is, you know, this is again my opinion, one of the things that differentiates us from all other nations is the fact that we have the best and the brightest who come to this country and participate in research, teach, and make our universities and colleges the best in the world, without a doubt. There's no question about that. So all this bill is doing now is taking a small step in a direction that would allow immigrants to participate in that fourth pillar, public safety, working as peace officers, allowing now immigrants, not visa holders, permanent residents from other states who are already serving in that capacity to be able to come to to Nevada and to apply and then go through the same process of vetting, of background checks, and an application that would allow them then potentially to receive a position in an academy and then potentially go on to serve. And that's really my real perspective on this bill and why I feel strongly about it. It allows immigrants to become even more American by serving the public at large. And with that said, I'll turn it back over to Senator Flores.
Madam Chair, Senator Edgar Flores, for the record, again, thank you for the opportunity to present the bill. And I just wanted to make it abundantly clear, this bill, when I originally drafted it in the Senate, was much broader. We've very narrowly tailored it in the interest of trying to find common ground and to allow for the opportunity to say, let's take a small step in this direction and allow for the next 2 years or the following years for different agencies to provide feedback and tell us whether or not they think that this is working. We are getting more applicants. We are getting a more diverse range of individuals. Is it working? Are we doing good? You know, I just want for the conversation to flow. But I, in the interest of finding middle ground, started with a very broad bill and now have this very narrowly tailored bill in the interest of finding amicable middle ground. Madam Chair, we are open for questions.
Thank you for that presentation, and thank you for responding to the emails we've all received. That was actually one of my questions. But we will now move on to testimony. It's Friday. We'll move on to questions from the committee, and we will begin with Assemblymember Goulding.
Thank you. Thank you for the compelling testimony. Senator, you covered some of the background checks that folks go through, and I'm wondering if there's the folks that have been honorably discharged from the military qualify. Is there an analogous characterization when somebody leaves law enforcement that would come with them when they're applying for a law enforcement agency in Nevada that they've previously served in another state? Is there something analogous to honorably discharge that is an indication that they left in good standing?
Thank you for that question, Assemblymember Goulding. Through you, Madam Chair, Senator Edgar Flores thank you, Madam Chair. Senator Edgar Flores, for the record, I don't know if all states do that, but what I will say is, suppose you're coming from one of the 7 states we referenced. What you do is that you give the opportunity for the local law enforcement agency in the state of Nevada to have the opportunity to directly reach out to Connecticut, Colorado, California, Washington State, Kings County, whatever it is, the jurisdiction, and have a direct dialogue. This individual was there for X amount of time. What do you think about him or her? Do you think I think you have the opportunity to do that. I don't want to misrepresent the record and say that every individual that has left law enforcement will always have something issued. I know that in some jurisdictions that may be true, but I don't know if that's true always.
Thank you. Our next question is from Assemblymember Jackson.
Thank you, Chair. Thank you for this presentation. This means a lot to me coming from a family of immigrants. My question is, why does this bill specifically look at public safety officers? And either member or senator could answer.
Yeah, thank you for the question, Assemblymember Jackson. Ruben De Silva for the record. So, like I said, during my initial, remarks, that there's certain, ways that you can give back to this country. And again, this is coming from the scholarly community, but I also very specifically feel about this idea of how you participate in American society. And one of those has always been, public safety, protecting our neighborhoods, protecting our communities, being that officer in the community who's been given now and been bestowed by the state of Nevada the authority to do so. And we see there's very little evidence that immigrant officers are in some ways not dutiful or are bad officers. There's very little evidence of this. Oftentimes, if you look at immigrants who participate in these sort of roles, they tend to be even more hardworking, tend to be even more focused on exuding the duties that have been bestowed upon them. So that's really the real focus, I believe, of Senator Flores' approach to this bill. And then this is also very true. You look at New York City. Okay, New York City is a city that has a very strong immigrant character. You look at going back even to the 19th century, the amount of Italian Americans and the amount of Irish Americans who participated and served in that police department. I believe, again, correct me if I'm wrong, but the NYPD's actual symbol flag, I think, has an Irish flag in it. But that denotes just how important it was for those communities when they first came to the United States. In the eastern seaboard of the U.S. Boston is another example. Philadelphia is another example where you have a lot of these, especially Irish and Italian immigrants, who then became socialized and became a part of the participatory American society by becoming police officers and firefighters. It was really a way in, and now you have generations of those same individuals, families, grandchildren, great-grandchildren of those immigrants who are still in those roles, who are still serving as police officers, still serving as firefighters, still serving as public safety officials. So this is really, again, akin with teaching, akin with, getting involved in entrepreneurship and serving in the healthcare elements that are identified as some of the most direct ways that we can socialize immigrant communities, migrant communities into becoming dutiful, not just Americans, but dutiful Americans.
And Madam Chair, if I may add one additional comment to that. Assemblymember Jackson, thank you for that comment or question, better said. Senator Edgar Flores, for the record, representation truly does matter. And it is incredibly important, particularly in a time like now. If I could just use by way of reference, my neighbor was celebrating his daughter's quinceañera. And Assemblymember De Silva knows, and for those of you that I haven't had the privilege of having everybody join me in my home, but we live in a very tight-knit horse community. And our homes, we open them up for the community. Everybody knows where we live. We host up to 500, 600, 700 people at the time. We've had 1,000 at different events. We do a lot of things in our community because that's the way our community moves, right? And very proud to say that in Senate District 2. They were having a quinceañera, and I remember vividly that the music was loud. There may have been a noise complaint, and/or they just might have seen so many cars. And law enforcement stopped by. Northeast Area Command came over, and I don't recall the exact facts, if it was because they had an issue or if they just saw a lot of cars and were like, what's going on? But I remember them coming in, specifically into the backyard, and they started dancing to the music and joking around with the community, high-fiving. And it's because it was an individual who proudly wore the badge, but also proudly came from that community. And so rather than, I think of a different scenario where you just have a different individual who doesn't have that cultural connection, maybe in the middle of the vaults, right, of the most important dance for that what it represents in Latino culture, that transition from young into womanhood. What if that officer would have gone in the middle and interrupted that dance where it's the most important moment of that member of the family, the dad, and dancing with his daughter, and would have stopped it because the music was too loud? Even if the music was too loud, that individual was in tune enough to say, let me wait for that dance to end. Let me allow for them to go talk to me. Can you just put the music down? Dance, high five, and tell them this is a beautiful event, and walked away. That matters. But the only reason that individual was there and the only reason that individual could have the opportunity to engage in the community that way is because he's from that community. From my neighborhood, right down the street, there's a home that really they repurposed it and turned it into a church, and they do cultural celebrations, and it's beautiful. And I've been there twice, and respectfully, I still don't understand the full breadth of everything that happens there. But there are certain times when certain individuals are speaking that nobody else speaks. There are very important rituals that are happening. I remember law enforcement showing up, and they were there just to check in and say hello. They have a great relationship with them. But again, it's because they had that relationship, because they came from that community, that they were able to bridge and do certain things. I think with law enforcement today, in a time where we still have that discomfort, where community and law enforcement don't have as strong of a bond as we should, and we're building that on that. And I know law enforcement every single day is moving in that direction. I'm incredibly respectful and appreciative of that, because I know that is the vision, that is the game plan. They talk about it every time I have an opportunity to do events in Senate District 2. We specifically coordinate with Northeast Area Command. They come out and show support. Assemblymember Carter has been there when they go on horseback with us. Literally, they will come, law enforcement will show up on horseback. There is a beautiful thing happening in this state. Culturally, we are connecting the community to law enforcement. And I think the way we continue to build in that direction is with a bill like this. And that's why we're doing this. And that's why we're having this conversation in this time where we know that outside of this building, there is very divisive politics. But that is not true to us. I can break bread with anybody in here, regardless of what badge you carry of a political identity, and you know that. We are not the federal government. We are not the garbage that is happening and the rhetoric that's happening at that level. We are much better than them. And part of it is because of all the work we've put into it. Part of it is because we have the first female majority in the country. Part of it is because of the investments of nonprofits. We've been doing all the right work. I just want to continue moving in that direction.
Thank you. Our next question is from Assemblymember Karras.
Thank you, Madam Chair. It's hard to follow that. I know for a fact in my lifetime and beyond that all, or most, I should say, of our peace officers are former military. It's that original need to serve that they carry into everyday life and all the training that they received. I really have, I'm going to do a follow-up, Chair, but I'll let you know when. My first question is, I was not aware, I thought that when immigrants served in the military, that they received citizenship when they were discharged. So I'm a little behind the ball on that one.
Thank you for that question, Assemblymember Karras. Senator Edgar Flores, for the record. The short answer is no. It's not automatic. Individuals are eligible to apply for citizenship. In the majority of scenarios, there are some limited circumstances where, depending on the individual's status, they may be, particularly in wartime, there's certain rules that apply. And then at times we've allowed not just lawful permanent residents, but other individuals serve in the military. So there's certain little rules that can make this change. But in general, you are eligible if you serve as a member of law enforcement and you have an honorable discharge. You are eligible for a streamlined process or approach to becoming a U.S. citizen. At times, you just don't have time. You don't always take advantage of it. You always don't know. But more importantly, strategically, sometimes you don't do it. And the reason sometimes you don't want to do it is because some countries don't allow for dual citizenship like the United States allows for it. And say you want to send me to do very special operations in a very specific country, you want me to have that passport and not the U.S. passport strategically for different reasons. So there are times where you don't want to do that. And then beyond that, once you get out and you're honorably discharged, traditionally, just so you know, the pathway to becoming a U.S. citizen is a 5-year path. It takes 5 years from the time you become a lawful permanent resident. Typically, there's exceptions to that, except there are streamlined approaches. Or if you're married to a U.S. citizen, that allows you to reduce it to 3 years. So there are scenarios where there are streamlined approaches. But again, I just wanted to make it abundantly clear that that's not always the case.
Assemblymember Karras, were you requesting a follow-up? Yes, I am. You go ahead.
I was just about to ask for it, to be more formal. Okay, so this question will be more on topic. In the amendment, has this narrowed the first reprint to being only honorably discharged people that would be eligible to become peace officers? Is that correct?
Thank you, Assemblymember Karras, for that question. Again, Senator Edgar Flores, for the record. No. Part of the bill now, as in the reprint that we see today, is to clarify what was already in statute, that honorably discharged members of the U.S. Armed Forces are eligible to apply and be a member of law enforcement in the state of Nevada. That's clarifying language. We wanted to clarify that because we understand that there may have been some confusion and that wasn't always happening by different agencies. But the second thing that it does, and I wanted to make this clear, is that it also now, and this is new language. This is not clarifying language. This was not in statute before. If we pass this bill, the second component is that we're allowing now for lateral movement from those states that do allow for non-U.S. citizens to be members of law enforcement, that if they have been a member of law enforcement, that they could do lateral movement. So for the hypothetical would be moving from Colorado to Nevada.
And Ruben De Silva, for the record. Again, that's a really good question there, Assemblymember Karras. And this is also part of the broader, you look at the movement of immigrants within the United States now too. So there's broad movement within the country, and we're seeing now states that have one set of rules or policies for immigrants, then moving into a different state, and all of a sudden finding out that they can't work in certain arenas because of their immigration status. We had a great conversation about this last session with AB 226 about in-state tuition for certain types of undocumented students. This is very similar to that. So say you're a legal resident, a green card holder in Utah or Hawaii or another state that allows you to actually be a peace officer, be a police officer, category 1, 2, 3, and you move to Nevada, and all of a sudden, you're making that lat move, and then you apply to the to a department here, and they say, well, you can't do it because you don't meet the criteria because of your immigration status. So what this bill is doing is just allowing for this to not be a barrier for folks who are already officers, who are serving in another state, to come to this state and to just continue on the service as law enforcement officials.
Thank you, and that looks like it's all the questions we had from the, Assemblymember Gallant. Last question.
Thank you, Chair. So a couple questions. One, do our law enforcement feel like they have the tools necessary to be able to do the background checks to ensure that those that are here legally in this country with the work visa and the history, that they would be able to adequately do those background checks?
Thank you for that question, Assemblymember Gallant. Senator Edgar Flores for the record. So the first, I'll start off by saying we already have this in the NRS, and it's been there before this bill. So whatever mechanisms and procedures and databases they've implemented now to address that need has already been done. With that said, I also know that not all agencies were adhering to the NRS and following that rule. So I don't know if every agency feels confident that they can do X, Y, Z because they haven't necessarily been doing it. Now, I know other agencies have, and so for them, obviously, they already have the mechanism in place. But the other thing I will say, suppose that one agency is just unprepared. They're saying, look, we want to do X amount of years of background checks. We know that they've gone through the Department of Homeland Security background check. We know that they've gone through a law enforcement background check. But we're still not quite sure. We're interviewing family members. We're talking to friends, which is a typical process, right? You want to get a full breadth of who that individual is. And you say, we still have this flag because we're concerned. It says here that there's a few years that he was living in Argentina. I don't know what happened in those years. We can't get a full breadth of what happened in Argentina. Unfortunately, we're not ready to hire this individual. And that would be normal. That is completely okay. And that would be true of any U.S. citizen, by the way. If there's a gap in the history of an individual now, I'm sure law enforcement would say, that's weird. What happened in those years? Why can't we get a full breadth of what you did? It sounds like you're hiding that. You're not being front-facing with all that. We're asking you to prove what you did in those years. You're not giving that to me. You know what? We don't think this is the best time. When you're ready for that, come back. But I think that would be true today, even with the rules we have in place now.
Okay. One more question. Sorry. Thank you. Okay. So there's several other states that do allow this. So has there been any incidents with those that are serving in other states where they have had like a higher incidence of infractions or complaints, or have been caught doing anything nefarious that would, jeopardize our homeland security? Has there been any cases like that whatsoever?
Thank you, Assemblymember Gallant. Senator Edgar Flores, for the record. I don't want to misrepresent the record. I tried searching for that, and we reached out, and I wasn't able to find like a correlation where we could say, because we've been doing this now for the past 4 years, we've had these instances of situations that are unfavorable to what we stand for as a police agency, and when they went up or anything like that. Now, that is not to suggest that I was not able to find a case, but that does not mean that it hasn't happened. There may be a scenario where you're like, look, I just researched this and I was able to find something. I just didn't find anything that suggested that concern, because obviously if that were the case, then we wouldn't be having this conversation respectfully. If we were saying all of a sudden an influx of individuals who are trying to hurt our country or something like that, and I'm respectful of that, I just haven't seen any data to suggest that.
Assemblymember Gallant, it's an excellent question, and both parts, and I just want to touch briefly on both parts of your question. So the first part you mentioned about the work visas. This bill doesn't deal with visas. These are for green card holders, permanent residents who have a pathway towards U.S. citizenship. So that's really going to be the focus of this bill. And then also the education component is important here too. I know Senator Flores has mentioned this fact that I'm sorry, Ruben De Silva for the record. Sorry about that. It's really looking at this notion now that some of these agencies and departments are not understanding the law fully. Even myself, when we first got back from Iraq, there were many of us who are trying to look into law enforcement as a potential career opportunity. I myself was disabled. I was shot through the arm, so that no longer was an option for me. But there were many of my platoon mates who wanted to become police officers. And then we were told that you can't because you don't have a citizenship. Go get your citizenship first and come back. When the NRS itself at that time had mentioned that you could. You know, this is at, again, the height of the Iraq War. We had just got back from fighting a war, and we wanted to continue our service in these realms. So I think that this is also going to be an emphasis, you know, through the measure that and the sort of like ethos that Senator Flores is promoting through this bill. And then secondly, you know, I think this idea of you know, immigrants or green card holders not being, you know, maybe being some infractions. I just want to talk about the longer historical record of immigrants serving in these sort of capacities. You look at, you know, not just immigrants, but anybody who has not been given that full notion of being an American. You look at World War II. You look at the Tuskegee Airmen. You know, 11 states had explicit laws that said that African Americans were second-class citizens. You look at the record of the Tuskegee Airmen in that war. It exemplifies and is even better than other all-white fighter pilot units. You look at the most decorated unit in American history, the 442nd Infantry Battalion, which was all Japanese American. In that war, you know, comes out the most decorated in American history. So when you give immigrants an opportunity to serve in these sort of capacities and you exude a sort of duty and an Americanness that comes with it, they tend to overperform. And that's a sociological record going back at least the last 80 years. So I think that opening this option, you know, this is again a baby step, but we should be open to the idea of allowing, you know, non-citizens, specifically green card holders who are again on the pathway towards becoming citizens anyhow, the opportunity to serve in public safety.
And Assemblyman Mergalant, Madam Chair, one additional comment, Senator Flores, for the record. I wanted to make it clear also that right now, I don't know if you've all had an opportunity to hear about the Explorer program. This is when they're under the age of 21. Individuals who have an interest in law enforcement can apply, and they do that while they try to decide if that's the best fit for them before they become a full Category 1 officer. In that particular program today, in the recruitment, there is no requirement that they are U.S. citizens presently. So we are already opening the door and allowing these individuals to apply. And in that scenario, you could have a situation where an individual, unfortunately, goes through the program but isn't a citizen and might be stopped. And you have to wait a few years until he becomes a U.S. citizen. So what we're trying to do is streamline that.
Thank you. That was the last question from the committee. We will move on to testimony. Thank you very much for this presentation. As always, testimony can be provided here in person in Carson City via video conference in Las Vegas or over the phone, and instructions for providing testimony on a bill can be found on the agenda. We will begin testimony in support of Senate Bill 155 here in Carson City, and we are asking that you keep your testimony to 2 minutes, and anyone here in Carson City wishing to provide testimony in support. Seeing none, still seeing no one in Las Vegas, we will move to AVH. AVH, is there anyone on the line wishing to provide testimony in support of SB 155?
To testify in support of Senate Bill 155, please press star 9 to take your place in the queue. Chair, we have no callers for support at this time.
Thank you. We will now move on to testimony in opposition. Is there anyone here in Carson City who wishes to testify in opposition of Senate Bill 155? Please begin when you are ready.
Good morning, Chair Considine, members of the committee, Jason Walker, JASONWALKER, representing the Washoe County Sheriff's Office, as well as the Nevada Sheriffs and Chiefs Association. Standing in opposition to Senate Bill 155, although I would like to thank Senator Flores as well as Assemblymember De Silva for culling down the original Senate Bill 155. It was very broad, although we are still standing in a position of opposition, mainly unable to complete a thorough background check as referenced by Assemblymember Gallant. You know, I personally I was the backgrounds investigation sergeant for a long time, and The law enforcement background compared to a regular county background is much more intense. We've had some people back out of a sheriff's office background to go work for the county because they couldn't pass a sheriff's office background. The NRS that's referenced in Senate Bill 155 is NRS 281. The title on that is a hiring of state employees. It's not the hiring of police officers. Police officers outlined in NAC and NRS 289.110. At the top of that category is the minimum standards of appointment. Number A, have undergone a complete and thorough background check. Number B, U.S. citizen. Number C, at least 21 years of age. All large local law enforcement agencies in the great state of Nevada, minimum requirements are possess a current or valid post certificate, must be 21 at the time of application, must be a U.S. citizen. NAC requirements do give us a little bit of leeway as far as mandatory and non-mandatory rejection criteria as far as our hiring decisions. Furthermore, the legal framework. Obviously, one of the primary concerns is that, the law enforcement authority. Police officers often have powers that exceed those of ordinary citizens, including the ability to arrest, carry firearms, and conduct investigations. Most or some may argue that these powers should be limited to U.S. citizens who have a complete understanding of and allegiance to the laws and values of the country. Furthermore, public perception and trust. The trust between the law enforcement and the community is crucial for effective policing. Most or some could argue that if community members perceive that police officers do not share the same citizenship, it could lead to distrust or reluctance to cooperate. It is referenced in the amended SB 155, and again, thank you to Senator Flores for touching on that. Peace officers from another state. I believe it was last session. I don't have the current Senate bill on that, but I believe it was authored by Senator Harris. Whereas if you have a bad actor, peace officer in another state that is leaving in lieu of or for an investigatory internal investigation, that you have to note how they left with that post-commission. That may come into play in this. Senator Flores has talked about that this bill as written says that he is allowing them to apply. I understand that, but lastly, I would just like to touch on some of the words in this bill, in my opinion, are too restrictive. The bill uses shall, prohibits, and must not. I'm not suggesting a change to the bill, but it might be a little bit easier if it could just be permissive, as where law enforcement may or law enforcement can consider. We do understand that some agencies are in a need to hire people, and they're not getting the proper amount of applications. So, I can agree with that, but I also would think that, again, if there were to be a suggested change, if these persons that aren't a U.S. citizen, maybe they're further along an advanced process of naturalization. And again, standing in opposition to Senate Bill 155 from the Washington County Sheriff's Office, as well as the Nevada Sheriffs and Chiefs. And again, thank you, Senator Flores, for the conversations that we had regarding this.
Good morning, Madam Chair, members of the committee. My name is Janine Hansen. I'm the state president of Nevada Families for Freedom. I first want to say how much I appreciate Senator Flores and Assemblyman De Silva. They've always been very kind to me, and even though we often disagree, we always get along, and I appreciate that very much. We have some concerns about this bill. In some places, there is a severe shortage of officers, and not many have been hired. I'm talking about an article that was in California. They passed their law in 2023. This article is from 2024. It says some of the state's largest law enforcement agencies, including San Francisco, Oakland, and Bakersfield, said they haven't hired new officers under the law, and part of that is because they have legal concerns over whether a non-citizen can possess a firearm. Another issue, which you've already heard, is about background checks. They may be able to do a background check of what the person did in the United States, but they may not be able to do a complete background check of what they did in a foreign country. That information may not be available according to a report by Cal Matters. And so that criminal history may be unavailable, and that's a great concern to us. Representative Kat Kamick from the U.S. Congress in 2024 introduced a bill to prohibit federal funds at agencies employing non-citizens in law enforcement. under the current administration, this could become a reality, which I would think would be a big concern for law enforcement if they were to lose funds over this issue. We talked about baby steps today. Well, I've been here long enough to know that that's the beginning of opening something up for much greater access in the future. I've seen it repeatedly on many, many bills that they start this way and then they expand and expand and expand, and I have concerns about that. There is a difference between healthcare and law enforcement. We need to feel very confident about law enforcement, knowing our laws and knowing what it is to be an American. We want law enforcement to be American citizens, and our concerns, I've expressed our concerns. Thank you very much, Madam Chair.
Thank you. Not seeing anyone else here in Carson City approaching the table for support for, opposition for SB 155. AVH, is there anyone on the line for opposition to Senate Bill 155?
If you would like to testify in opposition of Senate Bill 155, please press star 9 to take your place in the queue.
Good morning. This is Lynn Chapman, Lynnchapman, and I'm the state treasurer of the Independent American Party. And I know and agree with the part of the law that's in place now that people who have served in our military can become law enforcement. However, I was laughing because I thought, gee whiz, I remember a few years back when gang members were going into the military to learn more about military ways and military operations and such, and then going back into their gangs to use that against Americans and American citizens and the U.S. We talk about small steps, but I always notice that the small steps in our state legislature usually turn into bigger steps from session to session. In Virginia, DACA beneficiaries they were pushing them to become police officers, including positions such as chief of police, deputy sheriff, and jail officers, which created a problem or a situation in which illegals can enforce U.S. law, and in doing so can arrest and take into custody U.S. citizens and legal permanent residents, which is really interesting because DACA beneficiaries can serve as police officers, but there's a problem when federal law generally bars illegals from possessing firearms. We have to remember that there's problems with undermining the rule of law that we already have in place, and and threat to the general public. General public needs to have confidence in their officers. Those people are sworn to protect them and uphold the law. They need to be upstanding citizens themselves. And how can we know if we don't even know who these people really are sometimes? Some of the people have no documentation when they come here, and some of the foreign countries that they're coming from don't have information on them. So how can we really know who some of these people are? So I have a problem with Section 2, Number 2. Has been employed as a peace officer in another state. Maybe they were vetted in the other state enough to get into law enforcement, and then they come here. I'm hoping that we don't open up a huge can of worms. We need to be very, very careful about all of this. The opinion shows that most people, 96% of the people that were doing the opinion on this, were against this bill. So let's be very careful in what we are going to do and moving forward. Please vote no. Thank you.
Thank you. I know that we have additional callers on the line. I am just requesting that we respectfully keep comments to 2 minutes so that we can get everybody who would like to testify on the line. So thank you, AVH. Next caller.
Hello, my name is Michael Ryan, Michaelryan. I'm a longtime resident of Nevada and a Marine Corps veteran. Please vote no on SB 155. In Nevada, to work as a peace officer, you must be a citizen of the United States. People who are not United States citizens should not be serving as peace officers in our great state. It is very difficult for law enforcement to completely vet the criminal background of foreign nationals. Please vote no on Senate Bill 155. Thank you very much for your time.
My name is Katrin Ivanov, I-V-A-N-O, Frank. Thank you, Mr. Chair and members of the committee. I rise today in strong opposition to Senate Bill 155, a bill that, while well intentioned, possesses serious concern for integrity, accountability, and coercion of law enforcement in our state. The presenter said that there was no any problems with background check, but the truth is they didn't look well enough, or in some cases they can't even see, even if they look well enough, because the fraud happens in the countries outside of United States. I know for countless examples, I live here for almost 30 years in America, and I've heard many stories from people from my country and other countries that people pay to get fake resumes, and also for the people in the American consulate. Some of the people that are American citizens that work in the American consulate are getting paid to close their eyes and not do thorough check and just let people through. Also, I want to give you an example. If China wants to send people here to spy on us, to look how we do law enforcement and things, do you think they're going to give them bad resumes? They're going to pump up their resumes that like they're perfect American lovers, and they love America, they will die for America, and they will set up spies whenever they want to. This bill has so many loopholes for people to harm us. There is a reason we fight hard to become American citizens. I worked 9 years to become American citizen on my paperwork. I came legally in this country. So especially after what happened the last 4 years of the millions of people that came in, and some of them were given paperwork that they will be able to become citizens. Prior to becoming citizens, they should not be also given a badge and a gun. I strongly urge you to vote no on this bill. The problem is not that. The problem is that the government does not support our men and women in blue. That's why we have low numbers and people not wanting to become officers, because our government seems to, including our local government, but also sometimes federal, they seem to protect the criminals, the illegals, the people that are harming other people, but not the law-abiding Nevadans, the law-abiding Americans that are paying taxes. Those people don't seem to be protected, including police officers. When they do their job, in a lot of cases, people will look at the color of the skin of the people, and they choose to support the color of the skin, even if that person is criminal, versus the policeman. Everybody jump on policemen first prior to looking at the case, even if it's self-defense sometimes. They try to blame the policeman, especially if race is involved.
Thank you, ma'am. If you would please wrap up your testimony. Thank you.
Yes, we have to get away from race baiting, and we need to support our policemen and protect them, and then we'll have better number of citizens. Thank you for allowing me to finish. Have a lovely day.
Good morning, Chair and Committee. My name is Jim DeGraffenreid, Jimdegraffenreid. I'm Nevada's Republican National Committee man here today in opposition to SB 155. In the states that currently allow non-citizens to serve as police officers, I believe that all except California require that candidates be lawful permanent residents of the U.S. Even as amended, however, SB 155 still allows temporary residents with work authorization to serve. For public protection, detailed background checks are necessary for those who serve in positions of public trust, such as law enforcement. Existing law does allow U.S. military veterans to apply, and they have had appropriate background checks. However, because SB 155 expands eligibility to temporary residents, we have concern about how this will be accomplished in those cases. We appreciate Washoe County's comments earlier, as their agency is more familiar than anyone with the challenges posed by such background checks. We have public safety concerns with this legislation, which is shared by 96% of the more than 1,400 individuals who have shared their opinion on the legislative website, and we ask that you reject SB 155. Thank you.
Chair, we have no additional callers in opposition at this time.
Thank you. I would like to invite the presenters back up if they would like to make any final remarks. Oh, sorry. It's Friday. Thank you so much. Now move to neutral. Is there anyone here in Carson City who would like to testify in neutral on SB 155? Seeing no one approach, is there anyone in Las Vegas? Anyone in neutral in Las Vegas? Seeing no one, AVH, we're back to you for any testimony in neutral on SB 155.
If you would like to testify in neutral for Senate Bill 155, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in neutral.
So I'm just going to claim I knew that before. And if we could invite the presenters back up for any final remarks. Thank you.
Thank you, Madam Chair, and esteemed colleagues. Again, Senator Edgar Flores for the record. I just wanted to thank everybody for the opportunity to present the bill. And during the presentation on the Senate side, we did have a lot of members of law enforcement call in, explaining their particular story. In the interest of time, we asked some of them not to do it, and I know others were in training, but I just wanted to let you know that we do have that on the record on the other side. And then number two, I really do appreciate the opposition's concern of safety. It should be the number one concern any member of this committee, particularly any member of this body, should ever have. And I wanted to once again just reiterate that this bill does not mandate anybody to do anything. It is simply opening the door for them to apply. If we have any concerns on any gaps of their history, they can always reject the applicant the way they would do so today with an applicant applying. We have no interest in pursuing an obligation or giving somebody an added bonus simply because they're a lawful permanent resident. That's not what we're trying to do here. We are simply opening the door for those individuals to apply. And again, I thank you all for your time and the questions.
Ruben De Silva for the record. Again, I just want to ditto everything that Senator Flores mentioned about the background checks. I know it's an important concern, and even if, you have a law enforcement officer from another state who's applying to Nevada, and there's a concern from a Nevada agency, that individual can be denied. That this bill doesn't mandate any kind of forceful application process or giving them a automatic lateral movement into our state. So I do really want to emphasize that this bill is not about granting that sort of an allowance. And then secondly, too, there was a lot of discussion here in the opposition about this idea of upstanding citizens and so on and so forth. But I think there's also an important sort of differentiation we've got to make here when you look at the concept of the letter of the law and what a citizen is according to the letter of the law, and what the idea of citizenship is in this country. I remember back in 1993, I believe it was the year, my church, St. Christopher's Catholic Church in North Las Vegas, they gave our family the Citizenship Award to the De Silva family, Knights of Columbus, an organization that was very active there in our church. At that time, half of us weren't citizens and the other half were in our immediate family. My dad was a citizen and my two younger siblings. Myself, my mom, and my other brother were actually not just non-citizens, we were undocumented, in this country. But they gave us that award because we participated in the church. We were active, we were involved, we were exuding citizenship. So when we look at this notion, especially with some of the opposition statements about citizens, and upstanding citizenship and non-immigrants not being able to participate, in certain arenas of public service, I think we should consider that as we move forward. And with that, thank you for hearing us out today.
Thank you for the presentation, and Assembly Member, thank you for the service your service in our military, and thank you for being a teacher as well. I will now close the hearing on Senate Bill 155, and we will move to the last item on our agenda, which is public comment. Public comment is not an opportunity to rehear testimony on a bill, and we ask that you please keep your public comment to topics within the jurisdiction of the committee. As a reminder, members of the public can provide public comment in person or telephonically and may submit public comment up to 24 hours after the meeting. Instructions for providing public comment can be found on the agenda. If you are calling in telephonically today, dial 888-475-4499. When prompted to provide the meeting ID, enter 872-2300-3228, and then press pound when prompted for a participant ID. Each person will have up to 2 minutes to provide testimony. Please remember to clearly state and spell your name for the record. Is there anyone here in Carson City wishing to provide public comment? Seeing none, still seeing no one in Las Vegas. AVH, is there anyone on the line today to provide public comment?
To provide public comment, please press star 9 to take your place in the queue.
Good morning, Chair and members of the Assembly Government Affairs Committee. My name is Brittany Walker, BRITTANYWALKER, and I am City Attorney for the City of Boulder City, Nevada. Earlier this morning, you heard a bill, SB 279. I'm not here to provide testimony on that bill, but it opens up a chapter of NRS 289 known as the Peace Officers Bill of Rights. And we wanted to make sure that you are aware of an important issue that has come about as a result of a Nevada Supreme Court decision which came down in January of this year, holding that only a ranking peace officer can lead an employment-related investigation against another peace officer. The body of this opinion further states that the investigation is an internal investigation. We did not become aware of this issue until after the deadline for BDR introductions had passed. But this decision is extremely problematic, especially...
Ms. Walker,
yes?
I'm sorry. I know, I just want to step in. I know on public comment, we are not supposed to be re-talking about a bill, but if you're talking about a Supreme Court case, if you want to just talk about that case and not refer to the bill, but if it is referring to the bill, that public comment is not the right location for that.
Oh, I wasn't referring to the bill. I was just pointing out that the chapter was open. I was just saying the committee had heard a bill on this chapter earlier today. I'm not commenting on the bill at all.
Okay, please go ahead. Thank you.
Okay, thank you. This Supreme Court decision is extremely problematic, especially for small departments. Boulder City has approximately 40 police officers, and these individuals work closely together every day. Prior to this decision, Boulder City would routinely use HR or an outside law firm to investigate employment-related complaints, things like allegations of sexual harassment, discrimination, or retaliation. If the city police department was the only agency that could investigate allegations of harassment or discrimination, there would be no way to avoid even the perception of bias compromising the integrity of the process. What's more, the decisions holding that the investigation must be internal leaves only subordinates to investigate the highest-ranking police officers like our chief and deputy chief. I believe that NRS Chapter 289 has important protections for police officers, but I believe the Nevada Supreme Court's interpretation does not reflect the intent of the language. The Supreme Court was interpreting the section of law that specifies what information the notice to the officer must include, specifying the investigating agency must name the officer leading the investigation. I believe the intent of the section was to ensure that law enforcement investigated allegations related to police conduct, not employment-related complaints, are investigated by a peace officer. We're not opposed to peace officers having all of the protections of NRS 289, even in an employment complaint context. We simply want to be able to use HR or a third-party law firm to complete the investigation to preserve the integrity of the results and have the expertise necessary to properly evaluate the merits of the complaint. Employment law is an entire area of expertise, and if police officers are not well trained in this area. If the city is sued, it is not the police department or even the police officer on the hook for damages. It is the city, and we have an obligation, and respectfully, this legislative body has an obligation to ensure that the investigative process is unbiased. The bigger question we have right now is who would investigate an executive level peace officer like police chiefs? Their subordinates? I submit this issue for your thought and consideration and hopefully prompt action. Thank you.
Thank you. If you would like to submit that public comment in writing, please do so. AVH, is there anyone on the lines for public comment otherwise?
Hello. Thank you for the opportunity to speak again. Katrin Ivanov, I-V-A-N-O, Frank. I just wanted to say that if you are not looking for something, you will not find it. For example, in 2022 election, there were 90,000 people in Nevada that were not allowed to vote, yet they casted a vote. There was a pin pen project that went through the the names that they voted, the official records.
Ms. Ivanov, I'm sorry, the voting or those sort of operations are not in the purview of the Government Affairs Committee. Is your public comment directed towards the Government Affairs Committee jurisdiction?
It is. I was just making correlation that when you don't look for something, like the last bill, they said they didn't found anybody abusing these bills or somebody with criminal record that is.
And thank you, Ms.
So
Ivanov.
I didn't want to refer to the bill.
Okay, but
I didn't want to refer to the bill. I wanted to give a different sample of if you don't look for something, you will not find it. And sometimes even if you look for something, if the fraud is out of the state, you can still not find it. So I wanted to give a sample that's not connected to the bill, but it shows that when you don't look for something, you won't find it.
Thank you. We appreciate that public comment.
C-Y-R-U-S, H-O-J-J-A-T-Y. I just want to make echoing comments of the previous callers in public comment and in opposition. Thank you so much.
Mr. Hojati, are you opposing a bill and you're testifying in opposition? Public comment is not the right space, so if you'd like us to move that to opposition to the bill, we can.
Chair, we have no additional callers for public comment.
Thank you all. The next meeting will be Monday, May 5th at 8:30 a.m. in room 3143. That concludes our meeting for today. The meeting is adjourned.